Got to start?
Yeah.
Got a tie on too.
Good afternoon, all. Welcome to another CVLS monthly seminar. We have a small internal crowd, but a loyal crowd. Is that you, Dan? Oh, I'm sorry.
I'm Eric.
Eric. So let me give you a few dates. Welcome to our new space. This is CVLS's new offices. For those of you online, we are at 33 North Dearborn, Suite 400, and we are in our new conference room, which is a much nicer space than we previously had, especially for these kind of events. Coming up on December 11th, we will have our annual holiday open house, and we welcome all of you that are here today. Back to that, I know Aki will come, and Zig, and Mark.
No, I'm out of town, sorry.
Oh, darn. And for those of you online, feel free to join us. Our next seminar is on August 24th, and it is on using motions to frame and win your case. So it's motion practice.
You said August? You
I'm
said
sorry,
August 24th.
October 24th.
Okay.
The seminar thereafter is on November 6th. It's going to be a basics on immigration for people who do not practice in immigration. So immigration for divorce lawyers and collection attorneys and foreclosure attorneys and immigration for non-immigration lawyers. Today, however, we have a wonderful speaker. We want to thank Carol Casey for coming in. Carol's going to talk to us today about the Office of the Public Guardian and their role as guardian ad litem for the child. OPG often gets appointed in many of the minor guardianship cases that we handle, and they also are appointed often in domestic relations cases. So Carol will talk to us a little bit today about how OPG gets appointed and their role once they are appointed. So why don't we get started? Thanks, Carol.
Thanks. Hi, my name is Carol Casey. I'm an attorney supervisor at the Cook County Office of the Public Guardian. I'm currently in the our Juvenile Court Division, which is our largest division. I was in the Domestic Relations Division. I was doing impact litigation for our office. I've occasionally handled probate cases. So I've been around the block. Prior to that, I was at the Public Defender's Office up in Lake County. So a lot of the work that I do, while focused in juvenile court, carries me to different courts throughout the county, and frankly, I've had to go to court downstate in Jackson County, Illinois before, so I get around. And that's why I'm so happy to be here with you at the CVLS. This is one of the good places I get around too, because I love CVLS, its mission, and its attorneys, and so it's so wonderful to be here today. The trial ad professor in me has difficulty with the title called Who, What, Where, When, How, Why, without adding please explain and can you elaborate, but we'll go with what our title is right now. The Office of the Public Guardian is has a number of different roles, and so this title, this first slide really describes the fundamentals of what our office does and our missions. So we are the guardian of last resort for disabled adults with estates greater than $25,000 in Cook County. So we're going to talk a little bit, smidge about what a disabled adult is and about what we do in that division. Our other division, we are the attorney and guardian ad litem of children in cases in the Child Protection Division. So if a child is in foster care in Cook County, he's probably represented by our office. Occasionally we have conflicts where sadly some of our former clients have children. Those children come into the system. And occasionally siblings will have conflicts, or there will be other conflicts between children. But as a rule, if there's a kid in foster care in Cook County, our office probably represents that child. Additionally, in some cases, we are appointed primarily as child's rep in the Domestic Relations Division and Parental Court, and we do other cool stuff. So, a little bit of the background about our office. Here are a couple former public guardians, one of whom you may recognize, one of whom you may not. The first one is Mary Bartlemay, who was appointed public guardian in 1897. She's one of Illinois' first female attorneys. The cool thing about Mary Bartlemay is that her appointment as public guardian precedes Juvenile Court Act and Juvenile Court, which was founded in 1899. But generally cool character. The one that has gotten a lot of publicity is Patrick T. Murphy. And then to understand a little bit about our office, you have to understand where we came from. Oh, and our current public guardian, Robert Harris. Okay, so to understand the culture of our office a little bit is to understand that we were created out of lawsuits. And people were very unhappy with the representation that certain people were receiving. So in 1978, Patrick T. Murphy was appointed public guardian, and that was to work with disabled adults. So our Disabled Adults Division started being formulated in its current setup. In 1987, the public guardian started taking appointment in cases in juvenile court. And along those lines, our Domestic Relations Division was later formed. And as part of this effort to get really competent attorneys, we've set up various frameworks and various processes that we hope are attempting to maintain quality. One of the things that we are all really, really aware of is that nobody starts in life going, I want to be represented by the public guardian. We only come into cases because there are problems. We only come in because a court appoints us. And our clients never choose us. And we're aware of that. And also, as a rule, our clients, there is either a question about their capacity or there's been an adjudication as to the issue of their capacity. And for those reasons, I think we've developed this culture where we are very careful, I hope, about maintaining quality. And part of that is developed by our system of supervision. All of our divisions have supervisors who really consult rather fully on our practice. And if there's an issue on a case, we want to hear about it. If you can't resolve it with the assigned attorney, please give us a call, and I'll let you know who the various supervisors are, so we can attempt to resolve some kind of issue. Again, we could be wrong, and we want to hear about how we could be wrong. A lot of times we're not wrong. Also, part of our programming is that we are multidisciplinary. So in our Domestic Relations Division, we have case managers, and our case managers, as part of their mandate, go out and see our wards monthly. We have bookkeepers and accountants who manage our wards' estates. We have a psychologist in our Juvenile Court Division who also consults with our other divisions, and we have a nurse who also consults in all of our divisions regarding the issues involving our disabled adult wards, but also about our children who develop, who either we've dealt with medical evidence or chronic illness or sudden illness as well. We also are a site for MSW, obviously law students, MSW students, and we have psychiatric fellows from Lurie's. So we have physicians who do a round at our office as well. And we do this all because we're trying to gather as much information and knowledge about our clients and their situations. So that multidisciplinary practice cuts across the board. Also cutting across the board are, we have an Appellate Division, and that's been really critical to the growth of our office, because if you, just in my area of practice, juvenile law, if you do research in juvenile law in other states, unless you're going to hit on New York, who has their legal aid, or LA, California with LA, and some of the San Francisco offices, there's not a lot of appellate practice going on. Illinois is kind of unique with our appellate practice, kind of across the board, but especially in juvenile. We also have a legislative presence. So we're often called as witnesses in various committees to give our input on various bills. We have suggested legislative fixes to some of the problems that we face. And we also do other things. Back in the bad old days, there were thousands and thousands of kids in foster care, but there are only like 600 cases on the docket because those kids never came back into court once guardians were appointed. So based on a class action suit that we filed, the concept of actually we are going to enforce permanency rules in juvenile court. We've also sued DCFS for personal injury causes of action, agencies for injuries that our kids have received in foster care. So we're a kind of big, holistic kind of office. So Robert, by the way, was appointed in 2004. We are actually, pointed in the wrong direction, we're actually a branch of the Chief Judge's office. So I'm sorry about this slide being a little bit of a challenge, but you'll see us in non-judicial offices. There we are, buried between parenting education program and official court reporters. But we are a branch of the judiciary, well, not judges, obviously, and Chief Judge Evans and his predecessors have been pretty good about the fact that we are really independent. Even though our budget comes through the Chief Judge's office, we are really independent in our hiring and our management and our practices. In fact, there's an appellate court case that says if the judges are unhappy with what we're doing, they don't have to appoint us, but they can't direct us as to what to do. And that's, again, part of our culture is that independence, especially in our hiring. Somebody was mentioning that we had graciously mentioned that we have good quality in our attorneys. Part of that is caused by the fact that we hire people who want to work for our office and specifically want to work for our office. We are not hiring people who want to get a job practicing law and, by the way, perhaps I'd be willing to work for your office. We are very exclusive in our hiring and very focused in our training. So where are we located? 69 West Washington, look out the window. It's over there to the left. That is where our domestic relations division is and our probate division. Juvenile court, that's juvenile court. If you haven't come out and seen us recently, we're going through a little bit of a remodeling. We're really, really dirty at this point, but hopefully we'll get better soon. And juvenile court is 2245 West Ogden, which is Ogden, Roosevelt, and Western. So that's kind of the where, I guess. Let's talk a little bit about the what. Our disabled adults division, again, guardian of last resort for disabled adults with estates greater than $25,000. The state guardian handles those with estates less than $25,000. So if you come across somebody who you think might need protection and their family, friends, significant others are unable to provide that, and they don't have estates, the state guardian. When children exit foster care and require guardianship, if we can't find a family member, if we can't find somebody else to step in as guardian, we contact their office. So this is a point where I didn't put on the slide. The chief of our disabled adults division is Chuck Goldbert, G-O-L-B-E-R-T, 603-0800. So Chuck can be reached at 312-603-0800. There are a number of various supervisors and what have you who would be able to help you as well if you could just call and say, hey, I've got a question about. Oh, another aside, our floor is secured, so you can't simply stop by our office on the but it's on the 7th floor, 69 West Washington. So
For all the divisions? Is everybody on 7?
For domestic relations, probate, and to the extent that we do impact, that's where they are, on the 7th floor. We were on the 16th floor pre-fire. So, disabled adults. It's very funny, when I teach in school, a lot of times when I run hypotheticals, the solution is frequently, well, just get them a guardian and the guardian will consent. What's the problem? There are a lot of problems involved, and especially since we are a governmental agency, we do have restrictions on what we can do without the court's supervision. But generally, the people we are appointed wards on have mental deterioration or physical incapacity. Because of that, they're unable to fully manage their person or estate, or because mental illness or developmental disability, are not fully able to manage his or her estate. This gambling, idleness, debauchery, excessive use of intoxicants, we don't really come across it that often, nor do we come across people becoming wards because they were diagnosed with fetal alcohol syndrome. As a rule, we are not looking for people to become wards of. But our numbers, there are approximately 800 wards right now. And of our intake investigations, we have around 80 ongoing per month. So what happens is we get a call from an attorney, from the court, from a bank, saying, look, we're worried, from the state's attorney, from the police, saying that we're worried that somebody needs a guardian and may not be able to manage their own affairs. Around a third of our cases come in involving financial exploitation. We do have attorneys whose expertise is recovering assets on behalf of our clients, because you don't think it should happen, but people get their houses stolen, their bank accounts stolen, their stocks, their personal property can be stolen by an exploiter. Some of those people are their closest friends, their caregivers, police officers, attorneys. We've all recovered from those people. And remember, our requirement for taking on a case is an estate greater than $25,000. And that includes, in some cases, the possibilities of recovering that amount. I don't know if you're caring for elder caregivers or worked with disabled adults, but $25,000 does not go far at all. So anything we can do to access somebody's possessions, belongings, property, get that back to them, can really make a huge quality of life difference for our wards. So we're pretty aggressive in getting that back. We also cooperate, obviously, with the police and other agencies to safeguard elders. But elders aren't our only, the only people who are going to wardship, because 70% of our wards are over 65 and 49% have dementia, Alzheimer's, or other degenerative diseases. And that's kind of how we picture it. We kind of picture an elder, losing capacity over time. It's not always the case, because sometimes our clients are younger people with severe mental illness or developmental disabilities and traumatic brain injury. And so as guardian, we also have people obviously who have stroke-related illness or other disabilities. What you don't see there is physical disabilities, because as a rule, there's generally an alternative, and we tend not to get involved with that. But as part of our full range of services for the guardian of an estate, I mean, I've been to DUI court for our wards. We hire counsel, we communicate with public defenders when necessary, we arrange for services, we consent to some services, but we take on a full role of guardianship. And again, we're aware of it, because if you haven't worked on an adult guardianship case, there is an aspect, while we can get a plenary order, so we can be appointed just as guardian of the estate or guardian of the person or guardian of the person and the estate, or it could be plenary. We can be limited in the things as guardian that we can do. But as a rule, there's this aspect of legal death to it, isn't there? You're saying to an adult, you cannot make decisions on your own behalf. One thing we do as a substituted decision maker, if you haven't come across this problem, is that we try to, in fact, determine how the disabled person lived their life and what's important to them, and make decisions based on either beliefs that they've expressed prior to their disability, or ways that they have lived prior to their disability. If there is not guidance in that area, the standard is best interest. So that's our Disabled Adults Division. Our other division is our, yeah.
Can I ask a question about
Yeah.
the disabled adults? When you're going to recover assets, if you get involved, do you have to seek a finding of some kind of retroactive disability to
Yeah.
say that they were capable at that time, or do you do it based on fraud or some other?
We do it based on a lot of different things, but yeah, we do, obviously we do citations to discover assets. We do make fraud allegations. We do backdate the disability is part of it, is that, and usually you'd think it would be a challenge, but frequently it's not. Somebody's been disabled for quite some time. Yeah.
I've used the Illinois Department on Aging's hotline
Yeah.
to ask for an investigator. Could I go around them and come right to you? Would you send an investigator out?
It depends, but yes, if you make a referral to us, we will investigate it, and part of it means going out and seeing the potential ward and their environment and beginning to pull together basic bank documents and other property information. Perhaps you might not want to view it as a bypass, but as an addition to that.
Just a follow-up.
Yeah.
Where I used the Illinois Department, and they went out to see the alleged disabled or whatever, and they said, I don't want to talk to you. So the department backs off at that time. I said, that's it, I'm out of here. Same thing?
And we have a number of different tools to deal with somebody who doesn't want to talk to us or frankly can't talk to us, right? And we have in the past gone so far as to get 215A experts in there to assess and to get more information surrounding the person. But simply somebody's unwillingness to talk to us won't necessarily knock us out of the box.
Okay, thank you.
Yeah.
What and how do you charge for your services?
We do charge for our services as necessary. Because we're one of the few government agencies that actually give back, and it's one of our ways to maintain, frankly, funding and to keep us going. And I can't tell you exactly how we work out what our hourly fees are, but certainly we do go to court, we get approval for it. It's not like we're taking money from somebody's account. We get approval for all of that. Yeah.
I just, you had, one of your statistics that you have about 800 wards.
Yeah.
And then you also mentioned, the $25,000 goes, does not go far in the care of someone.
Right.
So do you have any idea how many of your wards, like what happens once the funds are diminished, or how many of those wards, start with about that amount? And then
Yeah, I can't give you those stats, but if you call, I could probably figure out what those stats are. But yeah, we try to maintain the estate as long as we can, because again, as a guardian, you have to be frugal in maintaining the estate. And we also we apply for public benefits. We try to set up our ward in such a way that if they do need to transition out, and $25,000 again doesn't go totally far, we do transition out with a plan. So if they're going to go to the state guardian, there's communication.
also, there will be a successor guardian once the
Oh, absolutely.
fund.
Yeah, absolutely. Yeah, we're not going to just kind of walk away and say good luck to you.
Well, I didn't know if you would maybe stay as a guardian.
No, because if you think about it, how we are supporting the guardian, and the state is set up. We are supporting the ward, and so we are supporting the ward primarily from their own assets and from public benefits that we're able to get on their behalf. Once they don't have assets, we can't expend that. They generally go to the state guardian.
Where do they go when the state guardian takes over? Is there a location?
Is there a location? No. I believe that like our office, we try to maintain people in the community as much as possible. Sometimes if somebody's like in a nursing home or whatever, it's more of a transition. It's not necessarily a change in placement. Actually, one of our first big constitutional pushes was the right for a disabled adult to remain in the least restrictive environment in the community. Cool. Okay, domestic relations. We are appointed in, the best way for me to describe it is really highly contested or complex custody fights, either in the Parentage Court or Domestic Relations Division. And we do the initial decree, and we also do post-decree work. And we are appointed possibly in 3 ways. The reason I say possibly is one of them we really don't pursue. One of them is being appointed as attorney. The other is as guardian ad litem. And the other is child's rep. So as attorney, we represent the child's stated goals, wishes, desires, we participate in the litigation. As child's rep, we advocate for best interest of the child in consult with the child, and we act as attorney, and as such, we have confidentiality and all the other things that go along with that. We can, however, communicate when we believe the child is at risk. As guardian ad litem, guardians ad litem can, in theory, not necessarily be attorneys, and they testify. They do not participate in the litigation. Those are the good folks who file reports that can be helpful in resolving contested matters. We do not take on that role. So it's the judge's decision how they're going to appoint us. We do not like that guardian ad litem role because we participate in the litigation. Our intake requirements are that one of the people have to be represented by counsel. And the reason for that is if we are left as the only attorney in the case, we end up being kind of the driving force behind the litigation. And if you think about it, where you have two fit and proper parents, that is not cool, right? So we need at least one person who's going to be an attorney. In our cases, mediation has to fail or has to be absolutely non-productive. So again, going through the statistics of the stuff happening at the Daily Center, just the mass majority of contested custody cases get resolved through mediation. So we're not going to get involved, expend resources until mediation fails. And also, the litigants have to be in Cook County. The reason for that is that we end up making numerous referrals. We occasionally go out to the home. We really participate in the life of the kid, and if the child lives out of Cook County, and if the litigants live out of Cook County, it is more difficult for us to make referrals and participate in that way. Any questions about domestic relations? Yeah.
We have an online viewer that's asking how many clients do you represent in that division? So presumably, how many kids are you appointed for?
Do you know, I don't know. That was, as I was leaving the office, I'm going, I wonder how many cases we're appointed on. We have 7 attorneys in that division, and...
Would you be willing to venture a guess? Do you know how big their caseloads are?
See, that's what I don't know currently, and I'd be unwilling to venture a guess on that. So, yeah.
Just a question about the GAL.
Mm-hmm.
Does the GAL represent the interest of the child, or does the GAL merely function as eyes and ears of the court?
GALs represent the best interests of the child, and I certainly understand, because I've also cited the law about how the child is, the GAL is the eyes and ears of the court. I think they probably mix together pretty well, that the GAL has to put together, has to investigate, has to determine information, but they are the eyes and ears of the court as well.
And the GAL reaches a conclusion in his or her report.
Yes, my understanding of it is yes, and I can tell you that in my role in juvenile court, we certainly reach positions. And again, it's the GAL role in domestic relations is one that I'm less purely sensitive to because it's one that we don't routinely take. As an aside, I was presenting at the National Association of Counsel for Children around a month ago, and I presented with people from Boston, which is a stated preference state, and with people from Colorado, who are a best interest only state, and then I was hybrid. And our conclusion at the end of that is that even though the roles are different, generally the ethical outcomes and the outcome to many of the problems were the same. And part of that is because we all are under ethical requirements as attorneys, and no matter what role we face, but also because of the requirement to investigate and to get information about the child and the child in their background, and the child in the background of their family, often those roles can be very similar, even if the punchline can be a little bit different. So our appeals division, we have, yeah, I'm sorry.
It seems to me more and more lately that Office of the Public Guardian is not wanting to take child rep appointments. Did you comment on that, or
Yeah.
did you comment on that?
Yeah, I can certainly comment on that. We close intake in our domestic relations division, because that's one of the areas where we are not mandated. I mean, it's good that we do it, we want to do it. I can say from personal experience, it's incredibly satisfying. But if we get overburdened, if our caseloads go higher than we can adequately represent, that division has closed intake. The biggest example was the one that I was involved with. I went to domestic relations after the fire when we lost a number of our attorneys. We closed intake. We simply couldn't manage taking any kind of new case in that situation as we kind of came back after that experience. And I don't know that we have done that as well, recently as well in that division. Side note, we have not hired an attorney in 2 years. And that is actually is creating a problem for us. And we can respond, we can shift attorneys around and whatnot, but it does become an issue. So, yeah.
What I was really asking is the distinction between being appointed as GAL and being appointed as child rep. And,
Oh, okay.
could you comment on whether the OPG's office has a policy as to which they want?
Child's rep is far preferable, far preferable. The reason, again, for that is that we prefer to participate in the litigation, and we prefer to put on evidence in support of our position. And I'm not denigrating the GAL's role because it can be critical and important, but we participate in the litigation. We want to fully participate in the litigation. And as guardian ad litem, you are not participating. You're testifying. You're not representing the child in a more legal capacity. Yeah.
But doesn't the court at least on occasion, appoint the GAL then after that role is completed as attorney?
Well, if the courts do it, I can't say definitely. I can say when the issue of when you go from one role to the other, from guardian ad litem to attorney, from attorney to guardian ad litem, one of the considerations that we have is confidentiality. So child's rep is a confidential relationship, so going from child's rep or attorney for the minor or a hybrid role to guardian ad litem only brings some issues, because with guardian ad litem does not come confidentiality. And so we try to maintain that we are going from one, when we're switching roles, we're going to one to the other. There is a case in re-AW in juvenile court where we were a hybrid appointment, and our appointment was later vacated as a child brought on counsel of their choice. I don't know if that is responsive to the question. Anything else? Okay. Juvenile division. Yay, that's my division. Juvenile division is by far our largest division with approximately 100 attorneys. We are appointed as attorney and guardian ad litem. It is a hybrid role. We currently have over 6,000 cases. To put it in perspective, we have had up to 37,000 clients at a given point. We have reduced our caseload significantly. When I started, and I granted had a very weighted caseload, I had 475 families that I was working with. Now we try to keep the caseloads 100-ish. But it was a radically different world back then in our representation. Interestingly enough, because of a recent Illinois Supreme Court case where that long-standing question of what is there a GAL role in a delinquency case, it was determined that an attorney for the minor cannot act as guardian ad litem. We've now been appointed as guardian ad litem in approximately 30 cases. If you think about it, well, my most elaborate case, and my client has given me permission to talk about it, was where he was co-defendant with his father in a murder case, and his mother was incarcerated out of state. In that case, my role was, part of my role was to advise my client, as a parent would advise their client. Like, that's not a good idea, that's a good idea, what have you. So that's an extreme example. A lot of our cases in that division come across where the complaining witness is a parent, so a domestic violence situation. So if a kid strikes his parent, arguably that could be charged criminally, it'll come into court. We also get involved sometimes when clients are highly mentally ill in that division. But again, the bulk of our labor happens in the child protection division. Our clients range from birth to 21. So there's a case, there's a lot of interesting case law out there. We don't represent fetuses, and there's case law to establish that. But from birth, when that petition is filed, we'll represent a kid, so even little itty bitty prematures, and the kids when up to age 21, when they can age out of the system. So our clients are often a moving target. You have to develop a lot of different competencies and to work with children of those ages. And one of the ways that we maintain that expertise is that we've developed, certain of our attorneys have certain areas of expertise. Mine is criminal delinquency and ethics. One of my colleagues, my partner, his area of expertise is DCFS administrative processes and rules, because we also litigate heavily in that arena. We have an expert on ICWA, Indian Child Welfare Act. We have an expert in immigration issues, because children in foster care qualify for special J visas, which means they can get legal status in the country. We have experts in adolescence and in emancipation. In fact, we can do an emancipation staffing and bring in all of our experts. We have experts in mental health. A number of our attorneys are JDMSWs, and we use them. Yeah.
How do you interact with CASAs?
We really appreciate the involvement that we have with CASA. CASA is an independent agency in Cook County, and it is I think it's 501c3, but it's housed in juvenile court. And we are very happy to have CASA involved in some of our more complicated cases. So CASAs will go out to the home monthly, will interact with everybody in the family. So we don't communicate with the kids except the parents, except through counsel or with the okay of counsel. CASA can work with the entire family in their environment. The other way that we use CASA is because if a kid of ours goes out of state, that implicates the an interstate compact. And what we do is we have CASA in Illinois contact CASA in the receiving state and see if CASA can work with the family there. A lot of times they'll just do a courtesy home study, or they'll continue following the family's case. So we interact with CASA on a regular basis. They are not on all of our cases. In some counties, like Kane County, the CASA is the guardian ad litem. So you'll have an attorney appointed for the kids and huge caseloads. The CASA, you will have like one CASA appointed per family. They will function as a guardian ad litem. So different role here because we're appointed as attorney and guardian ad litem, but we really do value the relationship with CASA. CASA also has people who has experts on teens and experts on medically complex kids. So we've used them in that area as well. And was there another question? Okay. Other areas of law that are implicated is interstate compact. When our clients go out of state, we will have an expert in that area of law. All of these experts have case laws and other duties, caseloads and other duties. We only become involved in juvenile court upon appointment. So, and generally that occurs on the first court date. So we get phone calls from time to time saying, we want you to become involved. Can you please help this kid? And our answer is sadly going to be no. We are happy to talk to you. We will attempt to send you in the right direction. We will try not to be that bureaucrat who says we aren't going to get involved until. But the truth is that we are not permitted to get involved until we're appointed. And we can only be appointed by the court upon filing of a petition in juvenile court. The other aspect of it is that we have to participate in every hearing that occurs regarding the child, beginning to end. So, yeah.
I was wondering, with over 100 families, how often do the GALs get in contact with those families? I was a CASA volunteer myself, and I never was able to reach my GAL, so I was just wondering what the guidelines are, how often.
Well, there are guidelines and then there are guidelines. The guidelines are is that you have to see the kid prior to once, and then once again prior to the adjudication, prior to first permanency, and prior to permanency thereafter. That is not giving you a view of really how we do it. We internally like to see our client before any major event, legal event, and surrounding change of placement. So permanency is a big deal for us, and I'll talk a little bit about how that process works. We also see our clients, and ANCRA requires, ASFA requires that we see kids or get firsthand knowledge of a child's condition. So in order to get federal funding, the kids in child protection have to have a GAL who can be an attorney who has firsthand knowledge. The kid also has a voice in permanency, either through their GAL or in person, about what their preferences are. But the reality is that we will see kids with great frequency, with a good bit of frequency, but we are not the case manager. We are not out there monthly. If you talk to some, I've worked on the issue about empowering teen clients, and a funny situation that has come up a lot, which is, I don't know who my GAL is. I don't have a GAL. I never talked to my GAL. And then the youth would come up and say, do you know Leslie? She's the best. You know, she's been with me through it all. And I'm like, well, Leslie's a GAL. Kids might not always have that knowledge of all those people coming in and out of their lives. One of our former wards calls them the alphabet people. So we try not to be the alphabet people. But bottom line, there are some kids that we see constantly. You know, I've gone to my clients' high school graduations. I've gone out into the interesting neighborhoods. We had one attorney, like, he'll pull over if he sees his client on the street and start talking to them. Other kids, frankly, if they don't want to talk to us, if they have rejected us, we will make a lot of efforts in order to see them. And once they come up, we will immediately go out and find them. And we keep looking for them. But some kids, as they're kind of dissatisfied with the system and dissatisfied with what's going on, we may lose touch, but we are looking for them. So we do try to maintain a real close relationship with our clients. Yeah.
Kind of off subject, but this gentleman asked about what fees you charge, and I think you implied that the fees were overall significant to kind of fund the operation, and yet you haven't hired an attorney, you said, in 2 years. How does that work out?
Yeah, that's what I say is yeah. Yeah.
Say above my pay grade.
What?
Say above my pay grade.
It's above my pay grade. And yeah, and again, we're really satisfied with the support that we received from the Chief Judge's office and the county, and we understand that we're stewards of the public welfare and all that. So that too. So the Domestic Relations Division, arguably we can seek attorney's fees and we don't. Not domestic relations. Domestic relations, we do seek attorney fees. Juvenile Court Division, we do not. And that is the bulk of a good push of our resources.
Is that the one you were about to say you arguably could in
You can
juvenile, but you don't?
Yes. I've, just as an aside, I represented a kid in a family where the families were millionaires. And I guess we could have, this was a long time ago, sought attorney's fees, and I think that we had the capacity to seek that. We just have not overwhelmingly. I don't know if you've seen Juvenile Court or know our numbers. We are overwhelmingly poor. Our families are poor, can be desperately poor. Our one of the great scandals, I think, of child welfare in Illinois is that around 85% of our clients are African American. And we know that abuse happens across the board, but for some reason, 85% of our clients are African American. So in our juvenile division, we are just working with people who are just struggling on a daily basis, and that's one of the things that we attempt to work with and understand our clients' life experience. So I digress. So a little bit about juvenile court. Oh, sorry. Juvenile court. You can't really see this. Look on our website and you'll get the real screen out about how it works in juvenile court, because a lot of times cases switch from division to division, domestic relations to juvenile, probate to juvenile. In juvenile court, pretty much all cases come in as an emergency hearing. Sometimes if a kid is safe, they will come in at a temporary come in with under summons, but still we're going to have temporary custody hearing to determine where the kid's going to live. Within 90 days, we have to get to adjudication. In the interim, the family will go to mediation. There will be a court-family conference where the court determines or works through with the family what services are needed, where the family's going, and what their status is. We also do case management because we do try to keep that 90-day trial date, and our cases can be enormously complicated because if we're dealing with a complicated medical case, sex abuse case, there are a lot of witnesses and a lot of parties. After adjudication, we have 30 days to get it to dispositional hearing. Adjudication is what happened in the past. Dispositional hearing is a snapshot of where the family should be legally. Overwhelming number of our kids enter the guardianship of DCFS. They might have been in the temporary custody of DCFS. They then go into the guardianship of DCFS. Thereafter, every 6 months, you have to have a permanency hearing where the court determines where are we going with this case. Back in the bad old days, when I had a caseload of 475 families, we really failed on that. And we had kids just floundering in foster care long-term, going from placement to placement, getting haphazard services. Now at a permanency hearing, the court determines what the goal of the case should be. Should it be return home? Should it be termination of parental rights? Should it be guardianship? Determines whether or not the services and the plan is appropriate. Really, does mom really need to have parenting skills classes when the issue is domestic violence? Maybe not. Or you might discover later in the case that the child has been sexually abused. Well, then we have to start looking at that. Or maybe in the interim, as it seems to have happened a lot over the summer, a sibling has been killed. Then we start looking at what services are necessary there. And we go through this permanency process until the child in some way exits the system. Our happy endings are when a child goes home successfully or a child gets adopted. We also have guardianship, where the family maintains the child and receives some subsidy. And in many cases, they just don't need DCFS and they don't need us anymore. The other way a child can leave the system is by aging out. And we try to keep the child engaged in the system as long as possible, and that's till 21. And kids can get a lot of services, including independent living. DCFS will help them find an apartment, will help fund their education, will provide therapy, will provide mentoring, teach the kids how to do their laundry, really think about what it takes for a kid to become a successful adult, and DCFS works with them on all of that. Or if a kid is disabled, we will start talking about transitioning services and start transitioning systems from DCFS to DHS, from juvenile court to the probate court. We really try to maintain kids in the least restrictive placement as possible, but some of our kids are institutionalized, and we have the capacity to work with our kids legally and going out and seeing kids. We have, when we talked about kids, about attorneys seeing kids in contact with kids, we have methods of seeing kids throughout the state of Illinois. where we all pool our resources, and based on courtroom staff from one courtroom will go out and see everybody's clients, say, in Carbondale. We also go out and see kids across the country. So once a year, we'll fly out to California. We will go down to Mississippi, Tennessee, Alabama, Florida, New York, and see our kids who are there. A lot of times, as a way to keep it down, like if a kid's in Buffalo, New York, I take that case because I go see mom, and while I'm out seeing mom, I see our clients in Buffalo. Or our kids in Austin, somebody's out for Christmas with mom and dad, they go see the kid there. And again, we pool our resources. If you're not simply seeing your client, you're seeing everybody's client when you go to Milwaukee. So we do have means of communicating with our clients across the country. The organization, so say if something goes bad and you need to talk to somebody or you just have a question, please call me. I love those phone calls. Really breaks up my day. I might not be able to talk to you right away, but do give me a call because I want to talk to you and help you work through that plan. I recognize that as a child's attorney, you're as good as the people that you know. And so I know the feeling of not knowing the answer or wondering what the next step is going to be, because I may call Meg Benson out of the blue and say, hey, do you know how to do this? And she'll take my call. So we try to take one another's calls. Organizationally, Yvonne Zaire is the deputy in charge of juvenile. Kelly Thornton is her assistant. Then it's me and my partner, Brian Finley, and we in turn supervise 6 or 7 courtrooms ourselves. And each one of those courtrooms has a lead attorney. So, but what you need to know is if you are involved with a family that's currently involved with DCFS in Cook County, you call 312-433-4300 and say, I need to talk to somebody about Johnny. And our frontline staff, our person answering the phone, will look it up, might put you on hold, we'll look it up and get you to the right person. We track kids by family name, not by family name, by the child's name, and we consider a case based on the mother. So if the mother has 7 kids, that citizenship can be handled by one attorney. So we might ask you what the mother's name if we have kids of the same name, similar dates of birth. So we do it based on that. One little thing that we run into problems with is that we deal a lot now with failed adoptions and failed guardianships. If you're calling about a kid that you think might have been in the system a while ago, try to find out what the child's name was back then if you could. Or even a date of birth, a first name. We should be able to track down that kid. But yeah.
What's the typical situation where the outcome where the kid exits the system through guardianship or a subsidized guardianship?
Generally, a child will be in the care of the parent, not the parent, the child will be in the care of a guardian, a family member who has been pretty successful working with the kid and getting services, cooperating, participating in services. In those cases, we go with guardianship as opposed to adoption or its return home. Guardianship is our second choice. Our first choices are adoption and return home. If that won't work because, frankly, we can't get unfit on the parent, but more importantly, we may not like what a parent has done, and we may not like the parent's relationship with the child, and we may be kind of horrified by things that have happened in this child's life. That parent is a parent of our client, and if that is an important relationship, we will go with guardianship rather than terminate parental rights in order to maintain that relationship. The thing that you get with guardianship as opposed to termination, Illinois does not have open adoption. So once a kid is adopted, the adoptive parent is a person who makes a decision on who that child sees, and they may want the child to see the biological family, they may not. With guardianship, there's a mandate for monthly visits, at least monthly visits, yeah.
Did the old age-out age used to be 18, or was it always 21?
I have been representing children since 1989, and during that entire time, the age-out age has been 21. At 19, the court has to have a hearing whether or not it's in the best interest of the minor and the community for guardianship to continue. Overwhelmingly, those motions are granted. Now, what you might be thinking about is that other states have not been so fortunate. So California, to a lesser, it's not New York anymore, but California in the past, you'd age out at 18, here's your hat, what's your hurry, good luck to you. Illinois has never been quite like that. There has been some split in practice between how we work cases in Cook County and how we treat cases in the rest of the state. Because the practice in Cook County, again, yay, Public Guardian's Office, we've been pretty aggressive in litigating that issue. Downstate, where they may not have had the resources, may not have had the organization to get it accomplished, cases would close at 18 and 19. But the law has always been 21 in Illinois. It has not always been, but in the past 20, 40 years has been 21. Yeah.
Can you explain how the post-degree situation works for post-permanency guardianship placements? What do families do when there's a
Sure.
request to terminate guardianship or
So you're
visitation
in-
issues or whatever?
You're in juvenile court and things, your case, the guardianship originated out of juvenile court?
Correct.
Okay. In juvenile court, we have the process. Our guardianship is actually, we close the case with a probate guardianship. However, and we do that in juvenile court. However, the Juvenile Court Act, Section 233, permits a case that's been closed in guardianship to be reopened in juvenile, as long as the kid's less than 18 years old. So if a guardian dies, becomes incapacitated, or a child wants to go home, right? Because remember, moving target. The needs of a 17-year-old and the 7-year-old is not the need of the 17-year-old. They can file a motion, and a lot of it comes in pro se into juvenile court, and we will get reappointed. The litigants will, the adult parties will be reappointed, and DCFS, post-guardianship unit, or CASA will start investigating the case. DCFS does have a post-guardianship, post-adopt unit. This is one of these things you have to pay attention to DCFS's budget. That area seems to be cut and reinstated and cut and reinstated. That is supposed to provide social work services for families in that position and help them work through, as a family, where do you think we should go when an adoption or guardianship fails? But ultimately, it can come into juvenile court and the case can be reopened, which is kind of cool because we don't have to say there's a problem with a guardian. We don't have to litigate the fact that the guardian may be unfit, unwilling, or unable. All we have to do is say, Judge, you declared this kid a ward of the court 10 years ago. Things are falling apart. As a ward, you have the authority to return the child home or to reappoint DCFS as a guardian. As an aside, one of the areas that Illinois, we're cutting edge, it doesn't feel that way on a bad day, but we really are cutting edge, is that we do have the capacity to reinstate parental rights post-termination. So those cases can also come in. So say that you've terminated parental rights and the kid never achieved permanency, which is our nightmare, or the kid has achieved permanency and the adoption has failed. Now anybody, used to be just DCFS, now anybody can come in and seek to reinstate parental rights. As long as juvenile court has jurisdiction, we can do that.
Only with juvenile court has jurisdiction.
Yeah.
Sometimes we're appointed as GAL in disabled adult cases where DCFS is petitioning or a family member is petitioning for guardianship of an adult disabled who has had juvenile court history.
Yeah.
What's the best way to get, or who should we contact for records from juvenile court cases to investigate the appropriateness of?
So you have a young, probably a younger ward who's doing that switch into that new system, and you've been appointed guardian ad litem. Probably the fastest way is just to call the front desk, and they will get you where they need to do. What we will ask that you do is get authorization to communicate with us. But say that you're in that area where the kid is, we're supposed to be starting planning at 17 and a half for that adult guardianship, and ultimately it would be achieved before the kid turns 21. So we could perhaps get it downstairs for us, juvenile court. You can get it in your appointing court, getting authority for us to freely communicate. So that's probably the best way to do it. We have done stuff like our clients have been charged with capital murder in Alabama, and they were wards more than 10 years ago. We're more than happy to talk to you. If we have a file, you get that correct authorization. And if you think about it, we've documented the kid's trauma background, probably better than almost anybody, and we can be helpful in that area. Sometimes kids just want to know where they came from. So we maintain files generally 7 years past the youngest child turning 21. So sometimes we have a lot of information. Cool? Yeah.
When a ward moves out of state, why not hook them up with the local public guardian's office instead of trying to maintain a long distance relationship?
Because that local public guardian has to be appointed by their court there, and there would have to be jurisdiction in the receiving state. And we have also public guardian, we are unique in Cook County. I don't know if I said that out clearly enough. We are unique in Cook County with public guardians offices. I think there are still 10 states where kids don't have right to counsel. You have to have a GAL. So yeah, we don't do courtesy, even though the agencies, DCFS and the receiving state, legally, there's a method of a receiving state managing that case. The actual attorney appointment cannot be subsumed that way. And I know what you're thinking, because you're going, wait a second, everybody has GAL. Why don't you talk to the person in Louisiana and get the GAL out in Louisiana? It's just not simply that clear who that GAL would be, and the law really doesn't have a method of achieving that. That, and frankly, we represent our clients, and we take that representation really seriously. We're not going to let go and say, we're not going to see you for a year or two, good luck. So that's the reality. Anything else? We are past time.
We are past time. I do have another question
Okay.
from an online viewer regarding the adult guardianship issues again. It is, does OPG support a ward who wants to remain in their home or apartment instead of moving into a nursing home? I think you commented a little bit on that, but maybe.
That was one of our first major lawsuits as an office, was to establish that a ward should be maintained in the community to the extent possible. It used to be you wouldn't receive federal funding unless you were in a nursing home, and a disabled adult wanted to live in their home. And usually that's in the best interest, or is supported by the way the person lived and by the duty to maintain their estate. Usually we want to keep people in the community as long as possible. There are times though where it's going to become impossible, and that's when we start talking about putting people in a more assisted supportive living. But our first choice is to keep the person in the community. Cool? Excellent, thank you so much.
Thank you, Carol. Thank you, everybody.
Oh yeah.
Will you be around for a little bit if people have individual questions?
Absolutely.
Great. Thanks, Carol.
I love it when they let